Federal of Evidence 44A, character evidence. Let's discuss exactly what this rule means. The general rule is the following. Evidence of a person's character or trait is not admissible to prove a person acted in accordance to it on a particular occasion. For example, about this first point is that let's just say I, as the attorney, am questioning a witness and I'm trying to bring in evidence to show that that person is a violent person. Okay, so technically speaking, I cannot admit evidence that the witness is a violent individual, character or trait, to prove that that person acted in a violent manner, acted in accordance to it on a particular occasion, let's say the crime scene, because that's the general rule. I can't do that. There are certain exceptions that we will discuss. However, for the general rule, basically evidence of that person's character cannot be shown that the individual acted in accordance with that character, example, violence of that witness on a particular occasion, the crime scene. In criminal cases, the second point here, in criminal matters, my specialty, in criminal cases, the defendant may offer evidence of his character, and if it is admitted, that will open the door for the prosecution to rebut that evidence. What does that exactly mean? To be more precise here, basically, this means that in a criminal matter, let's say the defendant is charged with battery. Okay, it's a misdemeanor matter, charged with battery for basically punching the victim across the face. That's the allegation here. And the defendant is trying to offer evidence that he, in fact, has a character or trait of peacefulness. That is an example of the defendant being able to offer evidence to show that he has a character or trait of peacefulness, and he's trying to use that character or trait of peacefulness to show that he did not commit the violent act of battery against the victim. The defendant can do that. Then, once the defendant does that, and if it's admitted into evidence, that'll open the door for the prosecution to try to rebut that evidence that the individual is peacefulness in terms of my example. So, if the defendant tries to admit evidence he's a happy person, then the prosecution may rebut that evidence to show that the defendant is a sad person, is a depressed individual. That is an example of a criminal matter in regards to this rule up here. Furthermore, the defendant may offer evidence of the victim's trait, and if that is admitted, then the state, the prosecution, may try to rebut it and offer evidence of the defendant's same trait. So a key example of this in a criminal matter is that we're still criminal cases here. In a criminal matter, the defendant may try to bring in evidence that, hey, the victim is an angry and violent person. So the defendant successfully admits that in the evidence. The prosecution, the state, may rebut it to try to show that, hey, the victim is not a violent, angry person. The person is actually a peaceful person, a happy person, someone who would never start a fight. That would be the rebuttal that the prosecutor will try to do once the defendant offers that evidence of the victim being an angry person. And the prosecution will also be able to show that the defendant has that same trait that the defendant is alleging the victim has. So like I just said, the defendant is trying to admit evidence that the victim is an angry and violent person. The prosecution will then be able to, like I said, rebut it to show that, hey, the victim is a peaceful person. But the prosecution will also be able to show that the defendant has that same trait of anger and violence. Last but not least, in homicide cases and only homicide cases, the prosecutor may offer evidence of the victim's trait of peacefulness if the defendant is trying to claim that the victim is the first aggressor. For example, in a homicide matter, Israel kills Riley. Israel gets a gun, shoots Riley in the head, Riley's dead. That confrontation happened in a murder charge. That's the homicide case in this example in 4.4a. So Israel is the defendant, Riley is the victim. And the prosecutor may try to offer evidence of Riley's trait for peacefulness if Israel is trying to claim that Riley was the first aggressor in their confrontation when the murder actually happened. Because again, when you think about the defense for self-defense, for example, if the individual is the first aggressor and the force is reasonable, etc., then that'll be a defense for Israel to get off of the murder charge, right? But the prosecution can try to rebut that by bringing in evidence of the victim's trait of peacefulness when the defendant tries to claim that the victim was the first aggressor who started the argument, well, the confrontation, to permit him to use self-defense. Just an example, but that is how the prosecution will be able to bring in evidence of the victim's trait for peacefulness in a homicide matter. And clearly, because it's homicide, remember, this section right here applies for criminal matters only. So again, in criminal cases, the defendant will open the door for the prosecution to rebut the evidence that the defendant has a trait, a good trait for peacefulness, for honesty, etc. But like I just said, if the defendant tries to offer evidence of a victim's trait of saying, hey, he's a bad person, he's dishonest, whatever, then if admitted, the prosecution, the state, may rebut that by claiming that the victim is a peaceful person and an honest person. And they may offer evidence of the defendant's same traits, saying the defendant is not honest and the defendant is violent. But remember, the defendant basically starts it first. Then the prosecution may try to rebut it.